Ladies and gentlemen of the jury, I am representing the defendant, the Ashford Hospital, in the case Jennifer versus the Ashford Hospital. Now, the plaintiff is stating that Ashford Hospital, in response to a subpoena not accompanied by a court order, disclosed the protected health information of the patient without her authorization. And according to privacy rule protections for information sought for administrative or judicial proceedings, the hospital failed to determine that reasonable efforts have been made to ensure that the individual whose protected health information was being sought received notice of the request and failed to receive satisfactory assurance that the party seeking the information made reasonable efforts to secure a qualified protective order. Well, according to the Code of Regulations, Title 45, Section 164.512, Subpart E, a covered entity may disclose protected health information in the course of any judicial or administrative proceeding in response to a subpoena, discovery request, or other lawful process that is not accompanied by an order of a court if the covered entity receives satisfactory assurance from the party seeking the information that reasonable efforts have been made by such a party to ensure that the individual who is the subject of the protected health information that has been requested has been given notice of the request, or the covered entity receives satisfactory assurance from the party seeking the information that reasonable efforts have been made by such a party to secure a qualified protective order that meets the requirements in the Section E. Now, the hospital, on its own itself, reached out to the client, and according to the Code of Federal Regulations, Title 45, Section 164.512, Section E, Subpart 6, it does state a covered entity may disclose protected health information in response to lawful process described in this section without receiving satisfactory assurance in this section if the covered entity makes reasonable efforts itself to provide notice to the individual sufficient to meet the requirements in this section, or themselves seek a qualified protective order sufficient to also meet the requirements. The Ashford Hospital sent the client a written statement and accompanied that statement with documentation advising her of the protected health information that may be disclosed or that could be disclosed, and also any litigations that she could possibly object to. Now, it does state also in the Code of Federal Regulations that a covered entity that receives satisfactory assurance from a party seeking protected health information must receive a written statement or provide a written statement and accompanying documentation that the party requesting such information has made a good faith attempt to provide written notice to the individual, or if the individual's location is unknown, to mail a notice to the individual's last known address. The notice should include sufficient information about the litigation or proceeding in which the protected health information is requested that allows the individual to raise an objection to the court, and the time for the individual to raise objections to the court or has elapsed. Therefore, the hospital did send the patient a written statement with the documentation to the address listed on file. Now, whether that address is previous, whether it's current, that is to be determined. But the hospital is not in violation, because according to this, even though the hospital did not ensure that the party seeking the information made reasonable efforts to reach out to the client or to the patient or seek a qualified protective order, the hospital itself sent the patient sufficient notice, and according to the Code of Federal Regulations, they were not in violation. They were allowed to disclose protected health information in this case. Therefore, the hospital is not in violation. I thank you for your time, and I hope you guys make the right decision.